Hello, everyone. Can everybody hear me? I'm just wanting to do a mic test before this hearing begins. Stand by. We're waiting for Judge Stephen W. Boyce in Idaho to begin a hearing when it comes to an objection to uh, John Pryor withdrawing as Chad Daybell's counsel. And we do have some breaking news before this hearing begins that Judge Boyce has filed an order to appoint co-counsel ahead of today's hearing. So this is going to be interesting. So for those just joining, we are waiting. It'll probably be another few minutes, hopefully just another few minutes. It's scheduled for 10 o'clock Mountain Standard Time in Idaho. Sometimes they're a little bit late, but sometimes they're on time. So we are waiting. I'm going to go ahead and put this on mute while I continue preparing, but that is what we are all here for. Let your friends know we're here. We're going to watch this together. Another interesting thing that I want to point out is there has also been a motion. This is interesting to unseal something from August 25th, 2023. So roughly 6 months ago, 5 months ago, actually, 5 months ago. But it's really interesting because it's a motion to appoint co-counsel that was filed August 25th, 2023, and it was sealed until today. So or we'll see. It's Yeah, the motion was sealed until now. So, I'm just going over everything. So, what I'm looking at right now is, court portal stuff. I'm just, like, reading the fine line, so that's why I keep bending down. I'm on my phone. Yeah, so we have a comment to unseal August 25th, 2023 order on motion to appoint co-counsel. And now, again, the breaking news is that Judge Boyce has filed an order to appoint co-counsel ahead of the hearing. So, to our moderators, I'm going to open messages here. Text me, please, if this starts without me knowing. Sometimes I'm going to busily refresh so that we do not miss this. But I am here. I'm going to just put this on mute while we wait. Big things coming down, though. Big things.
Okay, we are live streaming this proceeding. We'll be on the record on case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. Scheduled this morning is a hearing on defense counsel's motion to withdraw. A couple of preliminary matters before we get started here. The court will note there is an order governing courtroom conduct. The court is live streaming this on the official YouTube channel of the Idaho Supreme Court. I'm not permitting any other recording, video, or audio of the proceedings. So if you have a device that does that, that's not permitted. In addition, if you do have devices that make noise, please make sure they're silent or turned off to not disrupt the proceedings. And that's all set forth in the order governing courtroom conduct that's in effect for this hearing. I'll note on the record that the state is represented this morning by Rob Wood and Lindsay Blake, prosecutors for Madison and Fremont County. John Pryor is here with the defendant, Mr. Daybell, and the court scheduled on shortened time today's hearing after receiving a proposed motion to withdraw as counsel. That was filed on January 11th. There was a declaration supporting the motion, also filed January 11th. The court reviewed those and determined that the motions originally filed under seal would be unsealed, and they were. The state then, yesterday on the 17th of January, filed an objection to the motion to withdraw. I'll also note that the court entered an order just this morning that unseal the previously sealed order of the court as it related to a August 25th, 2023 order. And I've provided copies of that to counsel, but it does have some relevance to today's proceedings. So let me confirm that. Mr. Pryor, you would have already had a copy of that order, but from the state, Ms. Blake or Mr. Wood, did you receive the court's order unsealing the August 25th from last year order and a copy of that order?
Yes, Your Honor, they were provided to counsel today.
Okay, thank you. And they're doing construction right through the doorway here, so counsel could speak up probably into the microphones, unfortunately. Try to make the record as clear as we can here. Mr. Pryor, are you ready to proceed on your motion?
Yes, Your Honor.
All right, and who will be arguing on behalf for the state today?
I will, Your Honor.
Ms. Blake. All right, Mr. Pryor, then, as I mentioned, I've reviewed the motion. If you'd like to submit argument in support of the motion, you can do that at this time.
Judge, because of the microphone, may I have permission to remain seated?
You may, and if you just pull the microphone right up close there, Mr. Pryor, because of this noise from construction, that will be helpful.
And Judge, I was advised by your clerk that the microphones are doing quite well, and that I should probably, and is my voice at this point acceptable, Madam Clerk, in terms of the tone? It's not washing out?
Yeah, it's fine. We're picking it up. Thank you.
Judge, I appreciate the court releasing the order from 8/25/23. The court's well aware ex parte that I filed in January of 2023, well over a year ago, a year and 7 days, a motion to seek additional counsel. And the court identified the fact that at this point, being privately retained, that Mr. Daybell may not be eligible for having additional attorneys represent him. And I'm relying on the court's interpretation of that statute. And Judge, what has transpired, and as a matter of procedural history, in middle to late of 2022, I started the process of seeking additional counsel. I believe that was probably about 2 years ago. I started seeking a year and a half ago, seeking the possibility of getting additional counsel aid me in this case when I realized the magnitude of the discovery. That process involved, Judge, going through the list of qualified attorneys on the Public Defense Commission list. I took the process of identifying all of those folks and then reaching out to all of them. And the ones I didn't speak to directly, I spoke through the various public defenders the people who ran the public defender's office. I went through that list and at that point was unable to find anybody that was available to do this. And it's no secret, it's reasonable common knowledge that the Public Defense Commission is having a difficult time finding death qualified attorneys to represent in these kind of cases. I then contacted the commission on a couple of occasions and spoke to their one of their assistants and their directors and got the idea of maybe reaching out to out-of-state attorneys and did the process of contacting about 6 out-of-state attorneys to see if that was a possibility as well. And again, with no luck. Shortly thereafter, I went through again and went through the same process, looking through the list of qualified attorneys. In January of 2023, about a year ago, I reached out to the court and said, listen, it's going to require additional counsel. Mr. Daybell is indigent. He doesn't have the ability or financial ability to hire another private counsel at this point. And the court went through its analysis and thus came up with the order that you released today, Judge. What has transpired, Judge, is that approximately in, Judge, I don't want to misstate, so I want to be very careful about this, but I believe it was in October of last year, I reached out to a private attorney that I know and asked him if he would consider becoming death penalty qualified to aid me in this case, and he agreed to do that and started the process. He has been in relative contact with the Public Defense Commission, and at this point, up until today, when I spoke to him this morning, the holdup is the CLE, but that, you know, whether it's no fault of his or the Public Defense Commission, and I'm not putting any blame, but at this point, there's no appointment, there's no decision that has been made, and I'm really unclear because the commission won't tell me his status, only I can get relayed by what he's telling me. But it came to, I came to realize in late December that the amount of work that I'm going to need to perform before the trial was of such an extent that it would, in my opinion, create a situation where not all of the things that needed to be done for the trial commencing in April 1st could get done. This put me in a difficult situation. I want to relay to the court.
When you say December, what, December of this last year, 23?
December of 2023, Judge.
All right.
I realized at that point when there wasn't a decision about him being appointed, and the court obviously directed with its order that you'd be willing to compensate another attorney to help me. But in December, I contacted the attorney again. I was in relative frequent contact with him. And he said, listen, there hasn't been a decision. I said, you know, please contact them, find out what the holdup is. Where are we on this thing? And since that time, it was more than weekly that I was communicating with him. Up to today, there still hasn't been a decision. I don't know what the status is, and there hasn't been an approval. At this point, this puts me in the situation where this court, I don't think, is obligated to you know, appoint an attorney. Mr. Daybell has private counsel. And I want to state to the court that I don't desire to get off this case. I want to stay on this case, and regardless of Mr. Daybell's financial situation, I want to stay on this case. I could care less about the money. Mr. Daybell wants me to stay on this case.
Well, that's not really what your motion says, though, Mr. Pryor. Your motion says you want off the case because it's going to cost too much for you to work, the work it's going to take to get it through trial without compensation. So
Right, and that's correct, Judge.
this is an important issue for me today. Are you wanting to withdraw because you think you deserve to be paid for the work you do, which I understand, but when I'm considering the standards under Rule 44.1, which is discretionary under Part A, on a leave to withdraw, I may allow you to withdraw for good cause. And what I'm trying to determine is, do you want to withdraw because you're not being paid enough to continue through trial, or are you seeking to withdraw because you're simply not going to be prepared and ready for trial?
Judge, the situation is this, is that when I say to the court, and I'm saying that in all sincerity, I don't need to get paid for this case. the concern is this, is that at least at this perspective, Judge, I'm going to be doing this by myself. And it's going to expend a lot of resources and a lot of time that I'm not going to be able to commit to other projects or other situations. Now, obviously, I'm not taking on a lot of other obligations because of this case. Do I want to get paid? Everybody wants to get paid for what they do. Am I making that the only reason to withdraw? Well, it's twofold. Do I want to get paid for the work that I've done in this case? I do. I'd like to get compensated for the next 2.5 months and for the 2 months of the trial. And I do want to get paid, and I think it's fair. And Mr. Daybell and I had a discussion about this. Mr. Daybell expressed to me that he doesn't feel comfortable me continuing in this case if I'm not getting compensated for the work. And I advised him and told him that I don't need to get paid. I'm willing to do that. So if I'm not being clear, Judge, I'm willing to do it. Do I want to get paid and do I want to get compensated for this case? Yes. Do I think it's fair that I'm not getting compensated? I don't think it's fair. But it's twofold, Judge. The only way that Mr. Daybell is going to be ordered, or the only way the court can order Mr. Daybell getting additional counsel is if I withdraw. And that's the only situation that would cause the court to say, all right, Mr. Pryor's granted leave to withdraw because he wants to be compensated. Mr. Pryor wants to be paid for the work that he needs to do for the next 4 months. And Mr. Daybell agrees with me that it's not fair that I work for the next 4 months without being compensated. If the court decides to deny the motion, I want to make it clear, Judge, that I'm prepared to go forward and push this case to the end regardless. And I'm committed to that. Do I think it's fair that I don't get paid? No. Do I want to get paid? I absolutely want to get paid for the work that I do. And that's, you know, and if I was unclear in my my declaration, Judge, that's where I stand on this issue. But the only way for Mr. Daybell to get appointed 2 capital qualified attorneys, and the only, you know, and the purpose of getting capital qualified attorneys, Judge, is when the government has to pay for attorneys, they get to dictate what qualifications you need to be a capital defense attorney. I chose not to go through that process and get capital qualified, even though the criteria that they've established, I qualify. But at this point, I don't see any choice if I don't get assistance from another attorney to help me in this case. I don't have any choice but to withdraw. The primary reason is that there is no mechanism that I can see based on the court's interpretation of the statute that allows Mr. Daybell to get assistance mandated by this court unless I withdraw. But let me be clear. Do I want to get paid for the work that I'm going to do? I absolutely want to. And does Mr. Daybell want me to get paid? He does. Does he think it's fair? He does not think it's fair, and he wants me to be compensated. And that's where I stand on this. If the court decides that they're going to deny the motion and say, no, Mr. Pryor, I'm not going to let you off. I'm not going to harbor any hard feelings. I'm not going to harbor any dislike for Mr. Daybell. I'm going to go forward and I'm going to do the best I can. And I'm going to make an effort to try to find someone to help me, even if it's the day before trial. But again, let me be clear. Do I want to get compensated? Yes, Judge. Do I think this is fair? No. But by the same token, primarily, Judge, is the only mechanism I can think of to allow Mr. Daybell to get 2 capital qualified attorneys to help him with this case is if I step away and withdraw from this case.
Prior, going back to your preparation for trial, of course, this is a capital case, and if there's a conviction in the case, then under Idaho Code 192515, there's a special sentencing proceeding. And Idaho has adopted ABA standards for capital defense cases, and generally that requires, for example, the appointment of a mitigation specialist for the defense team as part of those proceedings. And I'm not asking you to reveal any defense strategy or even list a name, but the concerns I have here is you say you'll go through and do the trial, but I really want to know, are you really ready for this trial? For example, do you have a mitigation specialist that would be prepared in the event of a conviction in this trial?
Judge, if the court wants to have an answer to that question, at this point, I'd like to take a recess, close the proceedings, and disclose that issue because that is a trial issue and it's a trial strategy that at this point, I am not prepared to make an open statement on live TV about what my strategy is. If the court wants to take a recess, go in chambers, I'd be happy to discuss where I stand on this. In terms of the ABA standards, Judge, in terms of complying with the ABA standards, I'm aware of those standards. I'm aware of what that obligation is. But again, in terms of how I'm going to proceed in that manner, I would prefer to do that in either in chambers or in a closed proceeding.
Okay, and I think that's a fair enough request. Again, I'm not asking you to reveal trial strategy or publicly put that out, but these are legitimate concerns I have in weighing out whether or not Mr. Daybell is going to receive effective assistance of counsel in this case if you are permitted to remain on by me denying this motion. So I do want to get into that issue and discuss that. The state's entitled to know the answers to that as part of their objection to this motion. In lieu of doing that in chambers or off the record, it's got to be on the record. It needs to be in a sealed closed portion of the hearing. I'll determine under ICAR 32. And I think really the best way to do that, unfortunately, at the inconvenience of those in attendance here, is likely to clear the courtroom and allow that discussion to take place with only those necessary personnel in here to conduct the proceedings as part of a sealed closed hearing. So that's what I'll do at this point to go through those issues, and then we'll come back on in a public proceedings. So I would request that courthouse security and the bailiffs, if we could have everyone step out except for the clerk and the necessary security while Mr. Daybell is here. We will close this portion of the proceedings, and also for the bailiffs, if you could just make sure no one's within earshot of the a doorway as well, to make sure it's not carrying through on the microphones. And I appreciate your accommodating that. We'll also, of course, stop the proceedings from being live streamed, and then we will come back on the record once we're ready. We'll take a brief recess while that occurs.
All rise.
Wow. So we're taking a brief recess for those that just arrived. Brief recess. Thank you, Michelle, for that reminder to hit the thumbs up here. I'm also, I'm going to talk about what we learned during this recess, share some thoughts, read some of the objection that just came down. We do have the full objection to Pryor's motion on our Facebook page, facebook.com/into-crime. First, tell me if you guys agree. I think we need to slow the chat down for when the recess is done. I see a lot of people here. So let me do that too really quickly. Oh yeah, I'm okay. I'm going to mute that while I do that so you guys don't hear my keyboard. I'll be right back myself. Stick with us. All right, slowed the chat down. You guys are awesome. I was reading all your comments as they come down. For those just joining, we are in recess right now because one of the things Judge Boyce stated to Pryor is that he is really weighing whether or not he should allow Pryor to withdraw as Chad Daybell's counsel. just 4 months before trial, 3 months before trial. And he said one of the things Judge Boyce stated to Pryor that one of the things he needs to really understand is if John Pryor is ready for this trial. John Pryor said he's not willing to make a statement openly in public about that because he would like to discuss that in chambers during a recess behind closed doors, because it also has to do with his trial strategy, and he doesn't want to share that publicly. The judge stated that that was fair, and that is where we are right now. There are some interesting things. We're going to read the objection here in just a minute, but it was really interesting. I was a little confused, as John Pryor stated, money isn't an issue for him. He would like to stay on this case. And then he sort of stated, well, I would like to get paid. I'm okay not being paid. You know, Judge Boyce did call him out for saying, well, that's not exactly what the motion said. I do agree with Judge Boyce there. Pryor then came around stating, well, you know, would I like to get paid? Yes. You know, it's not always fair. I apologize about the little cougher in the background, guys. My little guy has been sick. You guys know that I was sick. Well, now it's his turn. So he is home from school. So that's what you're hearing. He likes to be near mom. So this is a family business. Okay. So let me read to you. So again, this is from Facebook. All right. So do you know what? I'm gonna share here. Nobody worry, because we still have Idaho Live and I'm listening, but I'm gonna just switch so that you guys can see this on our Facebook page really quickly. All right. So the state of Idaho objects to counsel motion to withdraw based on the following. Idaho Criminal Rule 44 provides no attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of a court on notice to the prosecuting attorney and defendant, except as provided in this rule. Leave to withdraw as the attorney of record for a defendant may be granted by the court for good cause. By the way, this is the state of Idaho versus Chad Guy Daybell. The state's objection to the prosecution's objection for the motion, to the motion to withdraw counsel. So to say that in simple terms, the state, the prosecution, those that are prosecuting Chad Daybell are objecting to John Pryor withdrawing or leaving as Chad Daybell's attorney. A trial court may appoint substitute counsel for a defendant upon a showing of good cause. An indigent defendant, I can never pronounce that word, so I avoid it. I say broke because we know what it means. Upon showing good cause. The attorney seeking withdrawal to present sufficient facts to support his motion, we will reverse the trial court decision only if it violates the defendant's right to counsel. The trial court decision will only be regarded as an abuse of discretion if it violates the defendant's right to counsel. To demonstrate an actual conflict under the Sixth Amendment, a defendant must show, 1, that his counsel actively represents conflicting interests, and 2, that the conflict adversely affected his lawyer's performance. Absent extraordinary circumstance, mere lack of confidence in otherwise competent counsel is not necessarily grounds for substitution of counsel. Okay. Did I miss a page? Let's see. For good cause. Sorry, I missed a page. A counsel may not withdraw. Let me just make sure I have this on. Counsel may not withdraw merely because his client refuses to plead guilty or because another attorney might possibly be able to convince the client to plead guilty. Counsel may not withdraw merely because his client refuses to communicate with him. A broke defendant has no right to select a particular appointed counsel, nor may a defendant manufacture such a right by refusing to communicate with his attorney. Otherwise, the defendant could forever delay his trial. The motion to withdraw relies in part on the defendant having been found indigent by this court on January 19th, 2023, almost a year ago. The state was not present or privy to any such finding by this court. Okay, full stop, full stop. The prosecution is stating that they had no idea that Chad Daybell was broke, that he was declared indigent. They had no clue. That's surprising to me. I don't know what to make of that, but I think that's an important point to just full stop and point out. They had no idea. The state was not present or privy to any such finding by this court. I'm really curious to this. So did nobody tell them? This wasn't public? As a year ago, the defendant and his counsel were apparently aware of the defendant's limited resources to continue to pay for his counsel services. But the issue is only now, as of January 11th, being brought to the state's attention. And as far as the state knows, this is the first time it's being raised as an issue affecting counsel's continued representation. Given the defendant and counsel being well aware of this issue approximately a year ago, the delayed filing until just over 2 months before jury selection is set to begin, this appears to be an attempt to delay the proceedings and part of a long-term strategy to delay and obstruct the state's efforts for justice for Tylee Ryan, J.J. Vallow, and Tammy Douglas Daybell. Well, that's interesting too. The prosecution is actually claiming that John Pryor has a long-term strategy here. I have always felt that this was a bit of a strategy, and the prosecution is accusing him of such a thing, that this appears to be an attempt to delay the proceedings as part of a long-term strategy to delay and obstruct the state's efforts. As stated, the state was not present for any hearing nor provided any order finding the defendant indigent. As such, the state is without sufficient knowledge as to whether or not at the time the finding was made, one, the defendant was advised of his right to capital qualified attorneys if he chose to request them pursuant to Idaho Criminal Rule 4420, and or if the defendant knowingly waived the right and chose to continue with private counsel, if the defendant did in fact acknowledge he wished to proceed with his privately retained counsel, which is John Pryor, and if that counsel, John Pryor, agreed to proceed knowing the defendant was broke, then the state believes that those factors are things that must be considered by this court in ruling on the pending motion. The affidavit in support of the motion to withdraw as counsel also references that counsel does not have sufficient time to finish preparation for trial and does not have the assistance of co-counsel for the trial or preparation. But the counsel, John Pryor, entered an appearance for the defendant, Chad Daybell, in this matter in 2021. That is the August. Is that the August? Hold on. So the counsel entered an appearance of the defendant in this matter in 2021 as solo counsel, and he has not changed his position, according to the prosecution. And I just lost my space. And I'm going to double check on everything too. We are still in recess, guys, and you are all here with me, right? Right. Okay. Oh, let me make this a little bit larger too. Let me make this a little bit larger. Does that help? Let me look. Okay, better? Okay, I'll keep going. And I don't know where I am, so I'm just going to pick a place and start. The affidavit in support of the motion to withdraw as counsel also references that counsel does not have sufficient time to finish preparation for trial and does not have the assistance of co-counsel for the trial or preparation. Counsel entered an appearance for the defendant in this matter in 2021 as solo counsel. As solo counsel, John Pryor has not changed this position. The defendant did not raise this as an issue prior to the last trial date of April 2023. To the contrary, the defendant relies on other tactics or arguments to successfully obtain a continuance and severance over the state's objection. This successful strategy has already resulted in the state and victims' families having to go through one trial while waiting a year for the start of a second trial. As a result, the defendant and his counsel were granted an additional year, an extra year, to prepare for trial, providing multiple additional benefits, including, so I have to go forward, including the ability to observe the trial of the co-defendant, Lori Vallow Daybell. In other words, John Pryor even got to observe Lori Vallow Daybell's trial. And it is true, he sat in there every day and he observed that. So while the affidavit in support of the motion to withdraw discusses hardships and challenges faced by private counsel, John Pryor, the record thus far does not support a finding which would require this court to allow counsel to withdraw. Given this again, it then appears this motion is yet another attempt to simply delay a trial in this matter. If counsel is allowed to withdraw, so if John Pryor is allowed to say, peace out, I'm no longer Chad Daybell's attorney, there will be a significant delay in bringing this matter to trial, which means potentially years of additional waiting for the victims and much higher costs to the state of Idaho. For example, it could also potentially result in an attempt to relitigate some matters, and the state would request the court enforce Idaho Criminal Rule 12 deadlines for filings, as well as other appropriate deadlines, which have passed if this motion is granted. Based on the foregoing, the state respectfully requests the court clearly establish a record as to whether the defendant is, in fact, broke for purposes of publicly appointed counsel, determine whether the defendant waived his right to publicly funded counsel, and ascertain from defense counsel whether he will, in fact, be ineffective at trial. Absent these questions being answered, the state requests this motion, the motion for John Pryor to withdraw, as denied. Respectfully submitting the 17th day of January, yesterday, 2024. Rob Wood and Lindsay Blake. So, there you go. We'll go back to court in recess. It's interesting if the state didn't know. If the state was not privy to that information about Chad Daybell. I mean, one could guess that he is broke, but was it actually made clear in court? And John Pryor also, I think this is something that's interesting too, is John Pryor did state that he hasn't been getting paid. I think a lot of us have been wondering, right? I mean, I certainly have been wondering. John Pryor has not been getting paid to be Chad Daybell's attorney. I think we've all been wondering. He owns the house. We've all been wondering, though, who's paying him. Is there some inherited wealth or Chad's parents helping out? Pryor made it fairly clear he's not been getting paid, and he won't be getting paid for the next 4 months. And Chad doesn't think that's fair. He also, though, noted that Chad Daybell does want him to remain his counsel and that he wants to remain counsel. I do feel that was a bit misleading in the motion that he filed where, I'm being very journalistic. I don't know if he clearly, it wasn't very specific. But he did imply that Chad was okay with him withdrawing. I guess you could say that Chad was okay with the emotion to withdraw and maybe not him withdrawing, but he said that Chad Daybell does want him to stay as his attorney. And I think it was good that Judge Boyce called him out on that, saying this isn't exactly what your motion implied. Your motion implied that Chad was cool with you piecing out on him and that you also were okay withdrawing as Chad Daybell's counsel. That is not what John Pryor just stated. He said, well, no, Chad wants me to remain his attorney, and I would like to remain his attorney and see this through. It's not fair. I'm getting paid. I'm willing to do it, not getting paid. So I am glad that Judge Boyce called him out on that. Like, what's what? I'm very curious what's going on behind closed doors. Again, for those just getting here, because I see that our views have gone up. I think most of you have been watching this, though. Pretty much there's a recess because they're in chambers right now discussing whether or not John Pryor is actually ready for this trial coming up in April. That was a very looming, heavy thing to read at the end of the prosecution's objection to John Pryor withdrawing as counsel. They pretty much stated this is a looming, heavy thing. They pretty much stated if John Pryor withdraws as counsel, we're talking years of preparation. Years. And Judge Boyce is stating to John Pryor he takes this very, very seriously. That he is going to allow John Pryor to withdraw possibly and rule on both these motions, John Pryor's motion to withdraw and the state's objection for him to not be able to withdraw. He's going to rule on this. And one of the biggest things he needs to know right now is John Pryor ready to go to trial? After all this time, is he ready? That's what's going on in chambers right now. We can't see that. We don't know. We don't know what's being said. John Pryor pretty much said to the judge he's willing to answer that, but not publicly because case strategy. Judge said that's fair. as fair he understands. So they're sealing this. This is off the record. Another thing that hasn't been brought up yet when it comes to this hearing that we're waiting for after this recess is the fact that there's going to be an unsealing of an August 2022, 2021. Oh, and let me check that date. I believe 2023. It's been a long time. This case has been going on a long time. The prosecution is right about that. This has been ongoing. So let me pull that the portal. I love that it's called the court portal, the court portal. So they're going to unseal 2023. Okay, right. So August 25th, 2023, there is an order to unseal that where it looks like Pryor was requesting a co-counsel nearly 6 months ago, 7 months ago. So we'll see that. So I don't know how long this is going to go. Judge Boyce is taking this seriously, so I wouldn't be surprised if this recess lasts quite a bit. I mean, they could jump back on right now too. So I think I'm going to put myself on mute. I'm going to stay here with y'all. I'm not moving, but I think I'm going to put myself on mute. I'm going to read up on a few things. I'm going to see what everybody's saying. I'm going to read your comments. So thank you for being here. I'll be posting some comments. So stick around. And then as soon as court is back in session, we'll all be here. Oh, I'll also say before I put myself on mute, Anna LeBaron, I saw you here today. Anna LeBaron is incredible. She is the daughter of Ervil LeBaron. And yeah, she has on Hulu a five episode documentary with her sister. We're actually hoping to have them on. We have to get permission to interview them. But I've been talking to Anna and because I would like to talk about this documentary. So definitely watch that documentary. And for those that want to see Anna's story, she is one of our first interviews on our YouTube channel. As in, she was so early on. I was in office. I didn't have a microphone. I didn't know what I was doing because this was our first interview on YouTube live that we did, the YouTube live. And so I'll try to also find her interview and post it here as well. I highly recommend that. So anyway, Anna, it was great to see you here. Some people have been asking about John Pryor's prior. We got a few emails about that. And yes, John Pryor has a prior. 2000, I don't know when it was happened. I think it went to trial in 2012. And yes, that is true. I believe what he was charged with back in the day um, was it was a May 2011 incident. Okay, it must have gone to trial in 2012. Felony battery and intent to commit rape was what he was charged with in 2011. So that's true. Like here, I'll post this. Oregon Live. Not that this has anything to do with what's going on right now. But for those wondering, and I'm watching the chat, yes, accurate. So I'll put this here. So there you go. For those asking. So I'll just read it really quickly. I mean, I've been going back and forth about whether to read it. You know, we're hanging out waiting for him. This isn't. Maybe I should do a separate live for this because I feel like it's kind of not completely on subject. But to answer people's question, yes, you can Google. How about that? Y'all go Google. But that is out there, definitely out there. Someone asking, why is the house, Chad Daybell's house, still sitting unsold and not turned into a liquid asset? Well, I actually, correct me if I'm wrong, somebody in Idaho, but I actually think his children or a child is living there. I think a daughter. I know which daughter. I think a daughter is living there. Someone correct me if I'm wrong, but I do believe that his house is in use and that John Pryor is not living there, but Chad's child. So I don't know if she's paying John rent. That could be the case. Anna, thank you. I don't know how to reply to individual people. The docuseries is called Daughters of the Cult. It's on Hulu and Disney Plus. The connection between my story and the Daybells is in the interview here with Hidden True Crime. Thank you for explaining that. Yes. As is a bit of your father's story. Ervil LeBaron, that's, you can wiki the 4:00 killings. Is that correct, Anna? I said that off the top of my head. Anna also has an incredible book. I thought I had it here, but I actually pulled it out. I've been rereading it. It's in our living room. Why don't you share your book too, Anna? Thank you, KCL. Yes, Emma and Joseph Murray, Chad's daughter and son-in-law, and their 2 kids are living in Chad's house. She is renting it from John Pryor. Thanks, KCL. Deanie bringing the tough questions, the questions we're all asking. I think bottom line is there is still, as we know, a lot of denial with Chad's kids. They simply don't want to believe, I think, that their dad is capable of the things he's been charged with. Janine, are you in the courtroom watching us right now? Are you there, Janine? What's going on? Tell us the latest if you're there, Janine. Be our boots on the ground reporter for us, or have you left? Are you waiting in the courtroom? Tell us what's going on. True, LA. If she's renting the house, that is income, indeed. Yeah, Natalie, that seems to be the case. The family could be continuing to pay through monthly rent. It's a great question, SL Conley. It's one thing seems to be that I've heard through an array of different sources that I've pieced together is they might believe that their dad was framed. So not a complete denial of two children's bodies being buried, but of their father being framed and him not having any idea of such a thing going on. Is what I've heard. Agree, Anna. We can hope. Okay, Janine, here she is. Janine is in the courtroom. Janine, what? I'm sure it's not easy to be on YouTube listening in your ears. And in fact, I assume, Janine, that you have me on mute. So why don't I write? I'm going to write Janine. Janine, give us a play-by-play if you can. I'll post your comments. Just in case she has us on mute, it would make sense that she does. Oh, I agree, Deanie. I agree. Okay, and anyone else that wants to encourage Janine to keep sharing what's going on? Okay, you're sitting right behind Whitney G. Okay, I did meet Whitney at the trial. Okay, any questions you have for Janine, ask her. How many? Janelle, it's good to see you here too. Janelle, by the way, did an interview with Hidden True Crime as well. You can find that. She's a friend of the program, and Janelle knew most everyone. She knew Melanie Gibb. She knew Chad Daybell. She knew most people that you hear about. You knew Lori Vallow too. She was, but Janelle was especially close to Tammy Daybell and knew Tammy and visited her just before she was killed. Good to see you here, Janelle. Oh, Audrey B. Thank you. Yeah. How can I forget? Audrey Baratario. Janelle was very close to Audrey, as was, yes. Janelle's ex-husband is Sean Littlebear. I hope that's okay that I say that, Janelle. We have Third Verse with us here too. Third Verse is Lori Vallow Daybell's first cousin. She's also appeared on our channel. It's so good to see so many people here. This is a really, really heavy hearing. It was ominous to read in that objection by the prosecution that if indeed the judge chooses that John Pryor withdraw as counsel, we're talking years, that we will not be going to trial in April. So to see so many of you here, Anna, Janelle, Megan, Connor, this is heavy. Janine in the courtroom. Thank you for this incredible community, though, that is here. Janelle, maybe you can ask Janelle about that, how Audrey is doing, that she's been worried about her. And Megan, how are you doing? Oh, and we even have Tom Evans here. Tom Evans was a juror number 18 at the Lori Vallow Daybell trial. Wow. This chat, this community, I can't believe who's here. My goodness. My goodness. I actually just got the chills. So many people here. And Tom has written a book about his experience being on Lori Vallow Daybell's jury. I can't imagine. And there's also a friend of Hidden True Crime, and we also have his interview here. Thank you for everyone for sharing who's here. Anyone else, please let us know. We're thinking of you. This is heavy, like I said. No, the trial has not been officially delayed at all. The trial is still scheduled and set to continue. But the one thing we've learned is that if John Pryor withdraws his counsel, it could be years before the trial. Laurie, I like what you reminded us of, though. I like what Kay Woodcock said, that whatever's going to be, they will wait if necessary. True. Chad collected, Girl Drink Drunk says Chad collected $420,000 on Tammy's life insurance. He gave $80,000 to his kids. When he and Lori were picked up in Hawaii, they had $180,000 in cash. Wow. I don't know if I've ever done all that math. Really? Wow. Oh, Janine comes with the update. Thank you, Janine. The only people here are the amazing law enforcement team that took him down. I assume that means like Detective Ray Hermosillo. People from the Madison County Prosecutor's Office, Fremont County Sheriff's Office, Nate, and the gal who oversees trials in Idaho. Thank you for sharing that, Janine. Thanks for the updates you're bringing us. Again, Janine is in the courtroom right now. Edie says she thought it was $8,000 each to 3 kids. That sounds more familiar to me. Yeah, I didn't know it was so much, but I'm not quite sure. I cannot confirm either of those. If anybody has the exact numbers or the documents that state, I am curious now. True, third verse. True, Megan. Yes, Chad is there. Oh yeah, Janine, is Chad sitting in there while they're all in chamber? Or is he with them? I assume he's with them, right? Not with law enforcement. Speaking of Tom Evans' interview, Leanne is saying, Tom, I really enjoyed your interview with Lauren and Dr. Babe. I also applaud your support of Hope House, a wonderful group of people. For those that listen to our podcast, we will be sharing Tom Evans' interview on our podcast today. We'll be putting that up. And so definitely check it out. Thank you, Janine, for letting us know. Megan, as a representative of Lori's family, maybe perhaps you have some insight. Shelley is asking, how does Lori's family feel about Chad's intent to throw Lori under the bus? Thank you, Lamisa. Yeah, any vibes in the courtroom, Janine? Oh, we have Aunt Vicky here too. Aunt Vicky, my dear friend Vicky. Vicky is the aunt of Tammy Daybell. Yes, Vicky, they are in chambers right now. The latest, Vicky, just so you know, is Judge Boyce said he takes the motion of John Pryor to withdraw very seriously and asked John Pryor directly. Here they are. So he asked John Pryor directly if there's no sound yet, right? He was ready for trial and they went to recess and they went into chambers.
Thank you. Please be seated.
We're back, everyone. I'm going to put myself on mute. Listen to Judge Boyce. Hear what happened.
All right, we're back on the record on case CR 22-21-16-23, State of Idaho versus Chad Guy Daybell. This is a hearing on defense counsel's motion to withdraw. The court conducted a closed portion of the proceedings to make further inquiry, and then in addition, conducted an ex parte proceeding without the states present to inquire of the defendant regarding counsel. And with that concluded, now the defense has presented their argument in support of the motion. So at this time, the court will consider the objection from the state, noting that this was a shortened hearing, so the objection was filed yesterday, which I do find timely. I have read and considered the objection, and Ms. Blake, if you'd like to present argument in support of the objection, you can do that at this time.
Thank you, Your Honor. First of all, the state recognizes that this is a decision that is solely within the court's discretion. I think Idaho Criminal Rule 44.1 clearly outlines that. It does indicate that a motion to withdraw can be granted, or excuse me, may be granted by a court for good cause. The state also recognizes that the Sixth Amendment guarantees a defendant the right to counsel. There have been additional courts that have reviewed that and provided some additional interpretations, which includes a defendant's right to conflict-free counsel. The state is appreciative of the court conducting an inquiry today because case law also lays out that a trial court's failure to conduct an inquiry into any conflict may result in a reversal of a conviction down the road. Additionally, the onus is on an attorney seeking to withdraw to present sufficient facts to support the motion. I think from the state's perspective, we are a little confused today because we read the affidavit that was presented to the court. Most of our motion was in response to that. The court has, in fact, done the inquiry and answered most of the questions the state had, also unsealing the order from the January proceeding where the defendant had referenced that Mr. Daybell was found indigent. We now have reviewed the transcript of that, and that did answer some of the state's additional questions, one being that there was an actual finding of indigency. The reason that that's so important in this case is because the Idaho criminal rules outline if someone is charged with a capital offense and they're found to be indigent, I think the term they use is needy, but the equivalent, and they choose to hire counsel, they're allowed to do that. They can have private counsel of their choosing. However, if they opt to request the court appoint counsel, then there's certain requirements, and that includes having a capital qualified first chair attorney and a capital qualified second chair attorney to assist them in the proceedings. In addition to that, it flags some additional requirements that the public defenders have to comply with. And there are quite a few of them in that list that must be complied with. But again, if a defendant opts to have private counsel, I think they do so knowing that their private counsel would not have to comply with those, or at least their counsel should be advising them of that. But they could also choose to forego having private counsel once they're found indigent in order to allow capital qualified attorneys to be appointed. In the review of the proceedings from back in January, it appears that there was a request to have some additional counsel assist on the case, and that was made by Mr. Pryor with his client, Mr. Daybell, present. At that juncture, it looks like Mr. Pryor was advised that if he could find someone else to assist in the case, that there may be funds available to help pay for that second attorney. In later proceedings, it looks like the court revisited that issue when no other attorney made an appearance. And at some point in those proceedings, Mr. Daybell was asked and essentially waived his right to have capital qualified attorneys. He opted to stick with Mr. Pryor. What's frustrating for the state is back in January a year ago, both the defendant and Mr. Pryor were aware of the defendant's financial situation. They clearly presented it to the court for the finding of indigency. At that juncture, they also were well aware that there was no second chair helping on this matter. So here we are a year later, and for the first time, this issue is being brought up that, hey, I actually want to withdraw because I'm not going to get paid. I'd have to work 24/7 in order to be prepared for trial and still probably can't get everything done in time for trial. So we've got two issues within that motion. One, the not getting paid, and the second one, whether or not Mr. Pryor can be prepared for trial. The state tries to be cautious in interjecting ourselves too much when it comes to a defendant and their choice of counsel. However, I think the ethical rules and other rules mandate that prosecutors try to ensure that defendants have the right or are advised and actually have counsel representing them in proceedings. When we look at that requirement of the state, as well as some of the other factors the state has to consider, such as appellate issues, the state tries to be cognizant of those and do our best to avoid creating them. I think that's what the court has indicated here today. The real question is, at least for the state, the finances the state's staying out of, but the real question for the state is, can Mr. Pryor be effective at trial? The state doesn't want to redo a trial. We don't want to get through trial and then have an appellate issue that requires us to do that again. While the state is extremely frustrated that this is being filed so late, and we are frustrated for the citizens, we're frustrated for the victims in this case. If this motion's granted, the state fully recognizes it's going to cause a pretty significant delay. And now the victims' families have to wait that much longer. The state now has to absorb additional costs. It's frustrating, but in looking at the big picture, we also want to ensure that we don't have counsel that cannot be adequately prepared for trial. When I said the state was a little confused today, the reason for that confusion is I'm referencing what was said in the motion. What's been presented here in court today is very different. So we have conflicting statements from defense counsel at this point. The motion read as if counsel was indicating, I cannot be effective. If you make me stay on this case, I cannot be effective. The reason I say that is no person can work 24/7 on something. We all have to have time to sleep. We have to have time to do other things. So I know it's a phrase used a lot, but the reality is if working 24/7, Mr. Pryor cannot be prepared for trial, what he's indicating is he would be ineffective at trial. What he's presented today is no, I can be effective. The motion says I'm not going to get paid. I want off the case. Today what's being presented is no, I'm fine not getting paid. I'll stay on the case. So if Mr. Pryor's representations today are I'm okay not getting paid and I can be effective, I don't actually know why we're here today. This doesn't appear to be a true motion to withdraw. The concern for the state is we've had multiple continuances in this case, and I recognize there can be arguments back and forth as to who did what and who caused the continuance. But at the end of the day, a year ago, Mr. Pryor was fighting very hard to get a continuance. He filed multiple motions to get a severance. He was finally successful with those in around January of last year. Maybe it was February, but he ended up getting both a severance and a continuance. Got a year-long continuance. Again, last January, Mr. Daybell had been found indigent. They knew there wasn't a second chair. He's proceeded on the case for a year. He had the benefit of watching the co-defendant's trial. He knew exactly how long that trial was, was able to observe and see how many witnesses there were, should have had a very good idea of what the trial preparation was going to require at that juncture. So again, very frustrated that we're getting here, but we had that. The request was, I need a continuance to test the DNA. We get past the trial. I'm actually not going to test the DNA. The state recognizes that different tactical decisions can be made, but it was very frustrating that we ended up with a continuance and severance for something that never ended up getting tested. Now here we are again, a couple months, I think today is actually 2 months before we're supposed to start some trial proceedings. And we're hearing a motion again on a request to withdraw, where the representations today differ significantly from what was put in the affidavit in motion. So this does appear to be another attempt to simply get a continuance. So the state's position on this would be based on the representations today. It doesn't appear this is a motion to withdraw. And if Mr. Pryor's representations today are accurate, then I think the motion should be denied. The one question the state has that has not been answered directly to the state, and maybe the court has this information, is there were some conflicting things also represented about Mr. Daybell and his specific position on this. In the affidavit, it indicated he did not want Mr. Pryor to remain on the case, that he wanted to have capital qualified attorneys appointed, that he didn't feel it was fair Mr. Pryor wasn't getting paid. Today, at least from the state's understanding, is we're hearing that Mr. Daybell does in fact want Mr. Pryor to get paid, so he wants him off the case. But then we're also hearing that Mr. Daybell would like Mr. Pryor to stay on the case. And I think that's really the important question today for the state is, does Mr. Daybell in fact want Mr. Pryor removed from the case? He's hired as private counsel. Is he in fact requesting Mr. Pryor be removed to have capital qualified counsel appointed? Because I think that's a different analysis and a different scenario than an attorney asking to be removed. So the state does not know the answer to that. I think we've.
Ms. Blake, I want to be careful because I had an ex parte proceeding, but in general terms, I think it's appropriate for me to advise the state that Mr. Daybell does desire to have Mr. Pryor continue in the case, and as you mentioned, is also very concerned and does not want him obligated to essentially work for free. So that's his overall position in general terms.
And I think that's where we kind of run into an issue. While he may not want him to work for free, Mr. Pryor was hired privately. If a person has the resources to hire private counsel, or if a private attorney decides to stay on pro bono, I think that's the counsel and the defendant's choice. I don't think there's any avenue to allow Mr. Pryor to be paid through another mechanism. I also don't think there's a mechanism that allows a public defender to be appointed to assist Mr. Pryor. I think under the statute, it's if you're indigent and you're asking for counsel, you get a first chair and a second chair qualified appointed. I don't think under the statutes and the criminal rules, I don't see any hybrid system allowed. So I guess the state's concern is if that's the position of both the defendant and counsel, then we should simply be proceeding to trial and this motion should be denied. It's not a true motion to withdraw. If Mr. Pryor is saying I can't be prepared for trial in April, the state's very frustrated that this is clearly just a veiled motion to continue with a different title attached to it. Because that appears to be the true argument today is I need more time. So the state's very frustrated with that. Mr. Pryor's already had a year continuance. I guess from the state's perspective, if Mr. Pryor is going to stay on, we're headed to trial in April. The state's ready to move forward. If Mr. Pryor is saying I can't be effective at that point, then I think capital qualified counsel should be appointed and we should move forward with that counsel appointed and selecting a new trial date. But I don't think Mr. Pryor should be granted a continuance if that's really what's being sought today, and that's what it truly sounds like is being requested.
All right, thank you for the argument and response, Mr.
Judge,
Blake.
can I respond briefly?
I was going to allow you a response, Mr. Pryor, so go ahead.
Judge, I don't think I've been inconsistent in my representations in my declaration and what was said today. This court took the time to inquire of Mr. Daybell, and I believe what Mr. Daybell related to the court is consistent with what was put in the declaration. The reality of it is this, is that I disagree with counsel, and I don't know what she's reading or how she's interpreting a statute, but this court entered an order allowing the assistance of a second counsel to help in the preparation of this case, and did it some time ago. The reality, Judge, is that although I've made a strong and diligent effort to find co-counsel to help me in this, it's been difficult and I haven't been able to accomplish that. And the reality is Mr. Daybell recognizes where we are in this thing and what needs to be done in the future. I don't have the benefit of Fremont and Madison County with their 5 attorneys in their prosecutor's office having free reign to do what they want at government expense. And the fact that both of those prosecutors then, in addition to their 5 state attorneys, sought out an attorney from Missouri and at county expense and on the county dime brought an attorney to work on a case that wasn't a death penalty case for the taxpayers of Fremont and Madison County to pay for that attorney, even though it wasn't a death penalty case. And that attorney is still on and still going in this case. And they've expended a significant amount of money, and I suspect it's not at the hourly rate that a prosecuting attorney makes in Fremont and Madison County. I suspect it's significantly higher. And for me to suggest that it's difficult with their 6 attorneys that they're working on this case, and I have to do this by myself, and the court recognized the
You've been
workload.
on a case for 2.5 years by yourself, and
I have.
all these attorneys, and the state carries the burden at trial, and they can prosecute a case they want. I completely agree with the state's position. The timing here, 2 months before trial is going to start, none of this is new at all. The charges have not changed since the indictment. The co-defendant went through an entire trial, which you observed and knew how long it would take. We talked about this concern a year ago, and here we are on the doorstep of trial, essentially. And the argument that is not persuasive at all to me is you're just learning now how much work it's going to take. Experienced attorneys, which you are, you figure out how long cases are going to take, and you pick and choose the cases you decide to take as a private attorney. And this argument that they have more attorneys than you, they do. That's what they've elected to do. And you've also elected voluntarily, as has Mr. Daybell, to come on this case and represent him. And you've represented him since the beginning, and in fact, even since before this case began.
And Judge, the issue also is that I per my representation earlier, is that in 2022, I started seeking out assistance and additional counsel. And I made a diligent effort. In fact, I took the extra step of seeking counsel who were death penalty qualified out of the state, out-of-state attorneys. I then tried to find attorneys on the Public Defender Commission list and made a diligent effort. And then when I found one, I believe in October of last year, my expectation is that he would have been on this case by now. But then we come into late December and I'm finding out that he hasn't been approved or put on the list, even though the court authorized the funds, and I'm in this position. As I've said before, Judge, it's not a matter of being ineffective. And for the prosecutor to sort of hint at the fact that I've been ineffective, I would remind the prosecuting attorney that the fact is that, and I don't want to rehash this, but any continuance was the result of them not turning over a lot of evidence, and a lot of evidence that I ended up having to go through and make a determination. So they can't put any continuance on me when it was their own issue in terms of the discovery. The other issues, Judge, are simply this, is that having made that effort to find these attorneys and help me with this case, I recognized that back in 2022. But being able to find someone is a whole different story. And the reality of it is this, is that I'm not making differing statements from what I said today and what I put in that declaration. I've spent a portion of my life representing Mr. Daybell, and I would like to have continued that. But he sees the effort that needs to be go forward. And my expectation was in December or November of last year, I would have had an attorney on by now to assist me in this, and that hasn't taken place. And under our current law, and the way the law is written, and the way the court has interpreted the law, the only way for me to get another attorney and to have Mr. Daybell have the 2 attorneys that he wants, and what it was said in that declaration and what is said today is still consistent. The only way to do that is for me to make the decision to step away from this thing. And to step away from this thing would guarantee and require Mr. Daybell to have 2 additional attorneys. Is it something I enjoy or want to do? No. Mr. Daybell knows full aware how I feel about this case and how I wanted to be involved in this case. There has not been any differing representations to this court. The problem is this, and I recognize, you know what, they get to gauge how many attorneys they want. They get to gauge the amount of money they spend. And in terms of getting assistance for a defendant, I'm bound by the rules and the way the rules are written by our state legislature, and I'm bound by the statutes. And being bound by those statutes, I have no choice. If Mr. Daybell's going to, get the trial that he deserves, either I find someone to help me, which I did starting in with this court in January, but well before that, and to no avail, or I have to make the difficult choice. And I understand it's 2 months before this trial. I understand that. and it's not a choice I want to make. It's not a decision that I want to make in this case. But that overriding want for me to stay on this case, or that need for me to stay on this case, is overridden by the fact that Mr. Daybell should get 2 attorneys to help him with this. I would have liked to have been one of those, but there's no mechanism to do that. So any suggestion that I've been ineffective is ridiculous. This case was severed. This case was transferred to Ada County, and Mr. Daybell would agree with me that I've done everything to strongly and effectively represent him in this case, and he is completely satisfied with what I've done. But there needs to be additional help. And unfortunately, under our current statutes, I don't get that if I remain on this case.
And Your Honor, I just wanted to clarify one thing so we have a clear record.
Go ahead.
The state has in no way insinuated or represented that we believe Mr. Pryor has been ineffective. What we were referencing is based on the affidavit written to the court that we felt that was what was being indicated, is if forced to proceed to trial, he would be ineffective because he simply didn't have adequate time to finish his preparations for trial. So I want to make very clear, we are not saying Mr. Pryor was ineffective. I want that very clear for the record.
I understand that, Ms. Blake, and I agree. The arguments have not been any ineffective assistance of counsel. The arguments have been related more towards going forward in the demands of a 2+ month trial, and whether, given the concerns raised by the defense, a single attorney, that being Mr. Pryor, would be capable of providing all of the defense necessary for Mr. Daybell in this case. So that will conclude submission of argument on the motion. I'm going to take a brief recess, review a few things, and then I'll come back on the record to make a ruling on your motion shortly.
All right.
Well, this is intense. I mean, again, pretty much on the line is the trial being pushed out for a year or years. So this is a really big deal. Again, this hearing, everyone's very passionate. Lindsay Blank did a great job, in my opinion. My non-journalistic opinion, I felt she laid out her arguments well. Judge Boyce, he did push back on John Pryor, but John Pryor came back with an interesting rebuttal that he simply has been trying to get co-counsel for quite some time. So Judge Boyce pretty much said, you've been knowing you've made this choice to represent Chad Daybell privately. This has been what it's been for 2.5 years. Of course, you don't have as many attorneys as the prosecution has, because you have made the choice to represent Chad Daybell privately. I liked that. I agreed with Judge Boyce. This is no surprise. So to do this, as Judge Boyce said, on the eve of the trial, just a few months before the trial, is really bizarre. John Pryor came back with a rebuttal that, well, he's been trying to get co-counsel for quite some time. That's a fair rebuttal, in my opinion. I don't know the ins and outs about it or the efforts he's made, but I'm going to happy birthday, Amy in Boston. Happy birthday today. I'm going to, again, put this on mute while we wait. Judge Boyce is going to make a decision today, and he's going to rule on this motion by John Pryor to withdraw from counsel, as well as the objection that the prosecution has made. They object John Pryor's counsel, or reject John Pryor's motion to withdraw his counsel. And I will say this too, there is a lot of word salad by John Pryor. I do agree that his motion says one thing, but he's saying something a bit different here today, that he does want to remain Chad Daybell's attorney, and he does want, and Chad Daybell wants him to remain his attorney, and money doesn't matter. We'll see. We'll see. I'm still processing a lot, just so you know, as I sit here and think about things. I'm just not ready just to talk it all out loud. There's a lot I don't know, I guess you could say. I'm thinking about everybody's arguments, everybody's rebuttals. Let's see what Judge Boyce says. Anyway, I'm going to hit mute. Again, thank you everyone for being here. This community is incredible. We have Tom, a juror, Tom Evans, a juror, number 18 from the Lori Vallow Daybell trial here joining us today. We have Megan Connor, Lori Vallow's first cousin here. We have Janelle Murphy, a good friend of Audrey Baratario and Melanie Gibb here, the ex-wife of Sean Little Bear. We have some people here in our chat. Janine is here, and she's actually writing and with us while she is in the courtroom right now. Janine, keep us posted on anything going on during this recess. We have Aunt Vicky, as I call her, Tammy Daybell's Aunt Vicky, here with us in the chat as well. We have Anna LeBaron, the daughter of Ervil LeBaron, who is the subject of a Hulu documentary. So many incredible people. Forgive me for those that I'm forgetting. I saw quite a few familiar names. Thank you, Anna. Thank you. Stephanie Budge. I always listen when Steph Budge speaks up. Thank you, Anna, for reminding people to like this video. Stephanie Budge says, Chad understood his right and attested to that. He accepted prior. This should be enough. Lamisa, thank you. Rest in peace, Tammy. We continue to fight for justice for you. And when it comes to justice for Tammy, I would say Chad Daybell's trial is the most important. Chad was there that night. Alex Cox was allegedly there that night, or his car was parked 2 hours away. His phone pinged. Not 2 hours, sorry. Like a mile away. For 2 hours, that's what I was thinking. His car was parked in the church parking lot. Or his phone was pinged. Rest in paradise, Tammy. We continue to fight for justice for you. Hear, hear. Thank you, Lamisa. I agree. There are actual heroes here in chat with us right now. Thank you to the heroes that are here. Megan, you bring up a really great point. He's not death penalty qualified, so in an appeal, Chad could say he didn't get effective counsel. Gosh. I'm no attorney, but geez, if anybody knows anything to what Megan Music is saying, it's concerning. Gina, she asks about the Silver Linings podcast with Rex and Adam Cox. It's nice that they're trying to help others through this tragedy. I agree. You know, I want to say I had a nice visit with Rex when I went to Jody Hildebrandt's plea deal in St. George, Utah. Rex was so kind. He's a baker, I learned, and he baked some cookies, and I had a nice visit with him and his wife. And thank you, Rex, for that. And yes, they have the Silver Linings podcast. Rex is Lori Vallow's uncle, and he attended trial. Justice could be stalled, manipulated, disrespected, and much more, but justice will not be denied. Thank you so much, Cindy. I really appreciate that. Justice for Tammy, Tylee, and JJ. Yes. That is what this trial is about. Exactly. This trial is about justice for Tammy, Tylee, and JJ. Justice for Charles is taking place in Arizona, although that's also been, they've noted in Arizona that it is a complex case. Yes, it is. So they are also waiting to set a new trial date there in Arizona for justice for Charles. I think you're right, Shady Lamp, that Tammy seemed like a sweet angel. I bet she was so loyal. I agree. She was so loyal to a fault. Forgive me, I'm sending a private text really quickly to a dear friend who's being affected by this hearing. Sending out immense love to Charles, Kay, and Larry, the superheroes who fought from day one and tried to stop all of this. Pryor created this mess on his own, waived his right to DQ, but regarded they knew Chad could barely afford Pryor, so they knew they couldn't afford another attorney the whole time years ago. Yeah, Pryor chose to not be death qualified. Death penalty qualified, I think she meant. Stick with us, everyone. Troublemaker Baker, you're absolutely right. This must be so stressful and painful for the victims' families. Absolutely. We sit here and watch this together, but I can't imagine right now being family seeking justice for Tammy and JJ and Tylee and having to watch this right now. Anna, thank you. Sending love to the families affected by all of this, especially those here now watching, listening. If anyone could and would understand, it is Anna, what she has been through. Anna's father, Ervil LeBaron, for those that don't know, was died in prison. And the LeBaron clan, Anna, did you share your book title? And I didn't see it, but Anna's story is just horrendous, what she grew up with. And you have a lot of empathy, Anna, and I know that you've cared greatly about this case from the very beginning and see similarities in this case as your families, similar to your families. Rabbit is saying that they are actively playing for the Judge Boyce right now, that he must make this decision in these moments. Thank you, Anna. The Polygamous Daughter. I knew it had polygamous in it. So Anna's book is The Polygamous Daughter. It is incredible. I recommend it to anyone. I'm on my second read right now. Many are being affected right now. The texts I'm getting tell me that right now, that I'm responding to right now. Thank you, St. Animals Fire. Anna LeBaron's current documentary right now is a series on Hulu, Daughters of the Cold. So I'm texting right now with Vicky Hoban. She's giving me permission to share a little bit. Vicky, again, is Tammy Daybell's aunt and my friend. Honored to call her a friend. And we've interviewed her a couple of times here at Hidden True Crime. You can see those interviews here. If any of our mods are here and can get those links, please share. Vicky was able to give a victim impact statement at the sentencing of Lori Vallow Daybell. And share her loss and the Tammy's family's loss along with Tammy's sister, Samantha. She is actually quite upset right now. She's very upset thinking that they may have to wait years at this moment because of this motion and the possibility of John Pryor withdrawing or needing co-counsel. She wants to thank everyone here today that continues to support her family. So she's giving me permission to share that. Vicky, we love you. We're sorry. Thank you for being here with us as we watch what happens next. This is a decision and a motion that could affect a lot of people. McSpunky, thank you for always gifting Hidden True Crime memberships. We appreciate that so much. McSpunky is a generous hidden gem who always is gifting our YouTube membership. So you can subscribe. That's all of those that are in chat have subscribed to our channel. Thank you for subscribing. We do subscribe only on chat just to slow it down a bit. But you can also join our channel for a monthly membership where you have fun emojis, and we're going to start to do in 2024 member only videos. And McSpunky is always gifting Hidden True Crime memberships. I don't know exactly how that works or who gets them. So if anyone wants a new membership, I think just being in chat is helpful. And I think it's random when people buy Hidden True Crime memberships for other members. It's a random choosing, but thank you to those who are always gifting memberships so that more can be a part of this community. Thank you. Thank you, Laurel. Oh, the Bearded Pampered Chef Consultant, which, by the way, Bearded Pampered Chef Consultant, I love your name. I just like want to be your friend. There's a setting they state that you have to change to allow yourself to receive the gift. If anybody knows what that is, please share. Troublemaker Baker, thank you for sharing Vicky Hoban's interview. She just shared it in chat. Because of all the people here, many of them have interviewed with us. Anna, Janelle, Tom Evans, Vicky. I will go back once this is over and I will add a lot of their interviews to the description of this video so that many of you can see and get to know them and the people that are going to be affected by this decision. Oh, Janine coming in with the tea. Stop it. Are you serious, Janine? She says, wow, Chad is getting really animated while talking to Pryor. He's grinning and using both hands. That is very unlike Chad that we've ever seen in the courtroom. Tell us more, Janine. Wow. You guys, Janine is in the courtroom, so she's definitely listening to this on mute. Like there's no way that she's got this, that she can listen to this with volume. So in the chat, ask Janine for more info. I've got to hear this. Keep sharing, Janine. Yeah, people are like, what? Yeah, wow, what got into Chad today? Does he look upset? Yeah. Is he looking happy? Upset? Tell us more. Thank you, Lumpy. Yeah, everyone's like, you got us, Janine. We got to know. We've never seen Chad Daybell blink in court. You've got us really wanting to know. I agree. It is scary. That's a good point. Oh, Lamise is saying, I don't know if Chad is upset. This is playing out the way those two planned. Let's hope not. Well, I guess what we're saying though is if it's going that way, that it means that I think the way it would go for John Pryor and Chad is if John Pryor remains Chad Daybell's counsel, right? I mean, they certainly don't want him to say, yeah, you're withdrawing as counsel. Emily coming in with the directions to accept memberships. By the way, I know Emily. Emily and I met at CrimeCon. I'm so grateful that you said hello, Emily, and I remember who you are. She says to accept memberships, click on the super chat $sign. And then number 2, memberships. Number 3, the 3 dots, and number 4, gift settings. Number 5, enable gifts. I'm going to leave that up a bit. So for anyone that would like to receive a gift from some of our generous gems that gift memberships to our YouTube channel, follow these directions by Emily on the screen. And thank you for writing that out, Emily. Many people ask, and I just haven't been sure myself. Troublemaker Baker, also, thank you. This is the setting to accept the gift subscription. Click the $sign, lower right corner, click membership, click gift settings, turn allow gifts on channel. Mary Cat, I definitely wonder too. Mom Central, I'm not a lawyer, neither am I, Mom Central. I get things wrong. I always look to my hidden gems to correct me. But I've heard from other lawyers it would be ineffective counsel without a death penalty lawyer. Great question, Linda. Lauren, she asks, can it be proven that Pryor did really look for attorneys? I don't know. I assume he must show some sort of receipts, right? Great question. I think it could probably be proven. The question is, will they make him prove it? To me. I agree, Megan Music. Sarita asks how Heather Daybell is doing. I think of her interview often. I hope she is well. Yes, Heather and I keep in touch, but she has desired to keep a very, very low profile and her privacy until the trial is at least over. But I know she leans on her family, and we saw her strength in the interview. We do keep in touch, though. Heather and I do keep in touch, but we keep all communication private there. Thank you, KCL. Hidden True Crimes interview with Tom Evans, juror number 18. And thank you, Steph Budge, for sharing Megan Connor's interview. Megan. Yes, Megan's interview is really important. And Megan is here with us today. That's Lori Vallow's first cousin. Just Mimi? It's crossed my mind. I've wondered. Will he continue to do this again and again to delay? I don't know. Anything new from Janine? This chat is going really fast. McSpunky, thanks for gifting another membership. This chat is going really fast for me. I want everyone to know I am not seeing every chat. I am missing a lot. So please don't feel like I'm avoiding or ignoring anyone. And thank you to those who are gifting memberships. Aunt Vicky, we can't imagine how anxious you are right now and what this is like to wait. Thank you for being here. Rebecca, thank you. Rebecca has just gifted 5 Hidden True Crime memberships. Thank you so much. texting. Just a second, everyone.
All right, we confirm the live stream's begun again. We are back on the record on KCR 2221-1623. The court has before it the defendant's counsel's motion to withdraw filed on January 11th. I've considered the motion along with the declaration in support of the motion. I've also considered the objection from the state. We conducted a hearing today where I heard argument from the counsel, Mr. Pryor, in support of the motion, the objection by Ms. Blake from the state. Also conducted a closed portion of proceedings and an ex parte inquiry of Mr. Daybell and Mr. Pryor. And I've taken all that into consideration in determining the ruling on the motion. The court first is governed by Idaho Criminal Rule 44.1, which under paragraph A talks about leave to withdraw. And I'll just quote that section. No attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of the court on notice to the prosecuting attorney and the defendant, except as provided in this rule. Leave to withdraw as the attorney of record for a defendant may be granted by the court for good cause. So we've gone through the procedural steps to get here for this to be properly considered. The rule allows the court discretion where it indicates the court may allow for withdrawal, and then looking at the standard of for good cause. So the court will first note to clarify in this case, this is a capital case. Idaho does have a separate rule governing the appointment of attorneys who are on a roster that are considered qualified to represent counsel or represent defendants in capital cases. That's Criminal Rule 44.3. And importantly, that rule only applies when a defendant is represented by a public defender appointed by the court and does not apply when a private attorney is retained in the case. And also importantly, where the court made reference earlier to questions about the mitigation phase, if that were to occur in this case under Idaho Code 19-2515, an inquiry to Mr. Pryor. And I'll note, and Mr. Pryor has correctly pointed out, that the ABA guidelines do apply to public defenders. They are not necessarily required to be followed by private counsel. Private counsel under Idaho rules are allowed to take on a case, capital case, and those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case, has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell importantly does have the right under the Sixth Amendment of the Constitution to counsel, and included in that right is to have the counsel of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell not only through the initial stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now, has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims, to seek a conviction if they believe they have the evidence to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial. So the court has a duty to try to timely administer cases, and while the rules generally slow things down a lot, there are reasons for that, but at some point the court has to consider the timing here. That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, the court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available attorneys. And quite frankly, I don't have any idea who would be appointed of the 2. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued, and I think likely for a long time, maybe a year, maybe even more. Because for new counsel to come in, start over from scratch on a complex case like this, not have any review of discovery or any preparation, they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed, and I've tried to accommodate that, Mr. Pryor. We had a hearing, it was exactly a year ago, on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, they would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. We're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the 2 concerns here raised in the motion really are, number 1, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client, although it may be difficult and he apparently will not be able to be compensated. It's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, then the court will permit that and we'll go through the procedure to get that properly done. So that's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that the motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied. And Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today. And I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference. So, Mr. Pryor, do you have any questions on my ruling?
No, Judge, thank you for your consideration.
All right, thank you. Ms. Blake, any questions on the court's ruling? All right, thanks everyone for your attendance. That will conclude today's proceedings. We'll be in recess.
All right.
Wow. So trial is still set. Trial is still set for April. So not only is John Pryor's motion been denied, he remains. Oh, look, can you hear him? Darn it. We were about to get some hot mic there of Pryor talking to Rob Wood and Lindsay Blake, but it stopped. Darn it. Okay. So John Pryor's motion has been denied. He remains Chad Daybell's counsel or attorney. The judge has offered him a co-counsel. It sounds like that's on John Pryor, though, if he wants to find one, that they will approve of that. And Judge Boyce has also stated the trial remains scheduled for this year, just a few months. Deep breath. Yeah, thanks, Lamisa. Deep breath, Jebs. Deep breath. I'm really curious what Chad and John Pryor are thinking right now, because in many ways, yeah. I'm gonna let this soak in. I'm not gonna say too much right now. I am grateful that Judge Boyce denied the motion, but I think there's more to this, and I've got to think about this. I've got to think strategy long term. But before everyone leaves, I've been communicating with Vicky Hoban, again, Tammy Daybell's aunt. We've been texting as well as her being in this chat. Hey, Vicky, I know you're here. We are going to do an interview today. So it's going to be at 4 o'clock Pacific time, 5 o'clock Mountain time, 6 o'clock Central, 7 o'clock Eastern. I'll have the link to that interview in the next little bit so that all of you know. But for those of you that want to hear from Tammy Daybell's aunt, I know that this has been really heavy for her, and she wants to speak up. So I'm grateful for her and grateful that she wants to share. So plan on that later today. Again, 4 o'clock Pacific, 5 o'clock Mountain, 6 o'clock Central, 7 o'clock Eastern. We will be hearing once again from Tammy Daybell's aunt Vicky. Thanks everyone for being here. Thank you for the gifted memberships. Thank you for the likes. Thank you for the subscribes. Thank you. We have an amazing community. Thank you for those that are so closely connected to this case to be here in chat and to trust us and know that this is a trusted, safe place to watch. It's been really touching to see all of you in chat, and it means a lot to me and to Dr. John to know that we can be a place you can turn to and feel safe while we watch really heavy things. So anyway, I'm going to let this soak in. I'm going to think about some things. I'm going to talk to some people, and we'll see you all here later today. See ya. Bye-bye.